What can I do for you?
Okay, so, let's see. I've got some questions that I've just got prepared on my phone here.
Okay. So this is an ongoing claim?
Yes.
Okay.
Do you have any, would you like to read the statement of claim?
Sure, yeah, or just even see the documents that you have so far. We're almost out of time here, so just... So it's surrounding an assault. Do you want to just briefly tell me what happened?
Well, it's more about a cover-up of an assault than assault itself. But so the question is, but the thing is, I mean, I'm not discussing that. That's just for background.
Sure. Yeah.
So my questions are about. So the stage of this process is right now that I've served the statement of claim to all of those defendants.
Okay.
And I've received statements of defense from all of them.
Okay.
And so I have not served the affidavit of records because I received the statements of defense. The first one was on May the 4th, so I understand that I have 3 months from the time.
You do, yeah.
So that's coming up on August the 4th.
Okay.
So the thing is, that's why I wanted to discuss this today, just because it is coming up, right?
Yeah.
Okay, so now, so first of all, my first question is, if I had to, could I apply to the court to get an extension to provide the affidavit of records? Is that possible?
So...
Just because I feel like I'm a little bit under a time crunch?
Yeah. What you can do is you can ask the defendants for an extension of time. That'd probably be the best way to do it. Really, nothing turns on you not doing it in time except for they can apply for costs. There's cost consequences in the rules of court. So just let me pull that up.
I see. So...
Yeah, so it doesn't really come down to the fact that the court's going to get you in trouble.
Okay.
It's more the fact that the other parties can potentially bring it up, and it could be an issue with costs down the road.
Down the road, but not immediately?
I don't think immediately, but let me check.
So basically, it'd be kind of like almost a punishment sort of thing for being late?
Exactly, that's what it is. It's just they try to keep things efficient. So they have certain rules in place that keep parties moving.
Right.
And that's kind of one of these rules. So just let me... Just going to...
Well, I don't want to take time.
No, that's okay. No worries. I just want to make sure I'm giving you the right... because this is the answer to everything, so...
Because... Well, I mean, just for your information, like although the first statement of defense was filed on May 4, like the latest one was filed on June 20th. So in other words, those people who filed their defense on June 20th obviously aren't like, they're not. I don't think they would feel the same sort of like chomping at the bit that the first people would be?
Yeah, I'm sure, to be honest, defendants hardly ever feel a chomping at the bit. It's normally only the plaintiff that does.
Oh, I see.
Yeah, defendants aren't really too fussy. But regardless, the rules say right here that... that's not it. I went too far. Lost my place. Here we go. So it says, or the first statement of defense if more than one is served. So regardless of the fact that the last people didn't
serve till
June, you have to do it by the first one. So whoever gave you that advice was right. So the penalty is right here in section 512.
Okay.
And it says, the court may impose a penalty of 2 times the amount set out in item 3 sub 1 of the tariff, and that's just the cost tariff, or any larger or small amount the court may determine on a party who, without sufficient cause, does not serve an affidavit of records in accordance with Rule 5.5. That's the deadline.
Right.
Or within any modified period agreed on by the parties or set by the court. So you can extend that time as long as you get either an agreement from the defendant or if you make an application to the court.
So I could, in fact, go to a judge and say, you know what, I'd like to have an extension.
Yeah, you could. You probably have to do that on notice to all of the defendants.
Oh, I see.
So it's probably worth contacting them.
Just to contact the defendants anyway.
To just say, that'll be easier than bringing an application, but if they don't necessarily agree, then you can. That's something that you can do. So I would that's probably your best bet, is to just say, listen, do you mind if I extend this for a time?
Well, then that's probably a good point, because, I mean, basically, so the reason why this is a difficulty, I'll just mention, is because, so let me just see here. So the reason why this is like a time-sensitive, kind of a time-sensitive issue is because, so there's 13 defendants there and 8 of them are police-related, right? Mm-hmm. So I made a complaint to EPS, and one of the amendments has to do with that complaint.
Right.
And so right now the complaint, I have an appeal ongoing with the Law Enforcement Review Board.
Okay.
So when you make an appeal to a complaint, the Law Enforcement Review Board receives what is called the record, right, of everything that was involved in the complaint.
Right.
So it's on 2 discs, and the first disc is like 1,100 pages of my complaint documents and everything that's related to it, all the police files and everything, right?
Yeah.
So now I'm not allowed to use that without permission because it's a separate undertaking, like it's related to the LIRB appeal.
Yeah.
And I want to use it for my lawsuit.
Okay.
So I have to make an application to LIRB to get permission to use it, right? So
gotcha.
And the thing is that, so I received that. So let me just read this here exactly. So that's the thing, is that I asked them. I sent written notice to LIRB to ask permission to use the record, right? And it's called. Let me just see here. Yeah. So you have to. Well, I mean, this is their wording: to be relieved of the implied undertaking to use documents in the record outside of the board's proceedings, right?
Right.
So that's like that's the wording of it. So I've done that, and I did that on July the 14th because this deadline was coming up, and they said, well, that's not enough time for us to process this because they have to get submissions from the lawyers representing the police.
Right.
So they said it's not enough time, and so I was kind of in a panic because I thought, maybe we could speed this up, but they said, nope, we can't do it. Okay. And so I'm having a hearing related to applications related to my appeal on August the 24th.
I see. Okay.
So I guess that's the reason why this was a panic situation. I wasn't sure what I could do.
Okay.
So, in other words, I could probably, I think what you're going to tell me, and I'm just speculating here, is that ask the lawyers if we can just simply hold off on filing the affidavit of records until after that.
Yeah.
That appeal, or that application hearing.
Yeah. You can do that. That would be one way to get an extension. The other thing too, though, is if you don't actually have those documents in your possession yet, if it's something you're waiting for, there's nothing stopping you from doing your affidavit of records. And then in the affidavit of records, in the rules of court, there are applicable rules for adding things, making supplementary affidavits of records for records that you later come into your possession. So you could just do your affidavit of records without these particular documents.
Right.
File it within the period and then add it later. You can even let them know it's coming if you want to. That's entirely up to you. But that doesn't alone preclude you from filing what you have now. So if you want to just get it done and try to keep moving this along, file whatever you have would be my recommendation, so that you're not offside the time limit. and then you can file a supplementary affidavit of records later
Right,
with the
right.
remaining documents.
Okay.
So that's one option. The other option, the easiest one would probably be to contact all of the defendants or the defendants' counsel and see if you can make a date for disclosure later. Or you could potentially bring an application to the court. I'm not sure off the top of my head, because I've never personally done one of these, whether it has to be an application on notice. So you might have to make the application and serve all the parties with your application and do it. I'm not sure if you can make it without notice. I think I saw you once in court making an application.
That's right.
Notice to,
Yeah, I recognize you as well.
Yeah, so to get the extension of time for serving the parties. I think the 1 year statement of claim,
That's
if
right.
I recall.
Yeah.
So I'm not sure if you can make an application in a similar fashion to just go into court without serving everyone and just ask them for an extension of time. I'm guessing it's probably something that they have a say in. So I don't know if the court's going to let you do that. So you might have to actually make an application by serving all the parties with an application. The application itself is $50 to file, so it's probably easier to just try and get consent from everyone.
Right.
Or just do it and file a supplementary affidavit later. That would be my recommendation.
Right. Okay. Yeah. So basically, just to summarize, so I understand completely,
yeah.
Just send them emails saying, you know what, I'd like to extend the deadline to pass this application hearing.
Just explain to them that you're still waiting on documents because you have to get permission to use them.
Right.
That's not going to be done till this. Just say, would you mind if we extended the deadline for the affidavit of records?
Right.
Till then. Yeah, most lawyers would probably grant you that extension. I don't see why they wouldn't. It sounds reasonable. But in the event that they don't worry. You can always file what you have within the deadline and then do the rest later.
Right.
If you don't want to be penalized or potentially penalized.
Right.
This isn't a guarantee. It's but yeah,
right.
You just never know.
Right. And the thing is about is that the lawyers who are involved in the LURB appeal are also defending the EPS members in my lawsuit.
Okay.
So they'll be aware. They are aware of the fact that I have the application hearing on August 24th.
Yeah, so they'll understand.
Yeah,
they will understand. So hopefully, that seems like a reasonable request to me.
Right.
I would assume that they would. So yeah, they'll definitely be aware. So you can try that.
Right.
That would probably be your easiest.
And the thing is, I mean, like obviously they're not the only parties, so I would still obviously have to inform the other defendants.
Yeah,
of
you
the
still
situation.
technically have to get their permission, right? It
Right.
has to be on agreed by the parties. Unfortunately, there's a lot of parties in your case, so you kind of do have to get their permission.
Right.
But I mean, if they're unreasonably withholding permission, that's not super fair. Also, it's beneficial for them because their time doesn't start to run for doing theirs until yours is served.
Right.
They have two months after. So, it might be a little bit more difficult for the parties that you don't have counsel with, but in that case, for those parties that don't consent, you can probably just bring the application to the court if you want to. Or again, like I said, you can just file whatever you have.
Right.
And then do it later.
Okay.
Yeah.
I
So
see.
you do have some options.
Okay, well,
Yeah.
that's good to know. So it's not a panic situation, really.
No.
I mean, I should get on it basically by asking for permission to wait until.
Yeah, it's never super great to run outside the timeline. I would never advise you to do that. But as long as you get on it and you at least, either get consent of all parties or get consent of some parties and bring an application for some. Even if you've set the application down before the 3 months is up, I don't see why you'd be penalized.
Right.
But yeah, try to stay on that deadline.
Right,
Sure.
right.
Yeah.
And I thought basically that it was, like you're saying, it's not really a court-imposed deadline, more like a party-imposed deadline. Like
Yeah,
it's kind
so
of,
I think it's, I think in order to penalize you, a party would have to bring that to the court's attention, and then they have the discretion to do it. And it says here, right, on a party who without sufficient cause.
right.
It sounds like you kind of have reasonable cause to be delaying because you're waiting for documents.
Right,
so,
right.
I mean, so this is completely discretionary, but it always looks better for a court to see you've made efforts to try and get consent.
Mm-hmm.
And that way, if it's one of the parties that's just saying, well, no, that's ridiculous, and they bring an application, they're probably not going to look very good.
Right.
Right? If they just refuse to grant you an extension of time and, You know what I mean? So I think you should be fine, but I would try to abide by it as well as you can and take steps to extend the deadline,
right.
just so you look good.
Okay, that's good to know.
Yeah.
So, and so the thing, okay, just to be, I just want to make sure that, because I'm not sure exactly how to do this, but so like it's called the record. Like, how do I refer to each document within the record, or do I just say the record? And then the thing is, I don't even need all of the documents within the record, so does it make sense to list them individually?
Yeah, so what you normally do, so there's normally, I wonder if they have an actual, do you have a copy of the affidavit of records? You don't have anything prepared?
No, I don't. No.
Okay, so we're going to go, I don't know if there's a
form on the...
Yeah, I don't know if there's a specific form, but let's check that.
I think there is.
Yeah, we normally just like use our precedent, so I don't even, I've never checked this out, but I'm pretty sure there is, in which case I can go off that, so.
Right.
So.
Yeah, I guess that's just it is.
Yeah, here it is. So Form 26. This hasn't been working.
Yeah, I've seen that message as well, where it, like, the thing about it is that it's an interactive form. So if you actually download it, it opens up with little like fields that you can enter.
Right.
And for some reason, it doesn't work on a browser, but it works if you open it up with Adobe Reader.
Yeah.
Which is kind of like an annoyance.
I know, and I don't know why, because it was opening up a civil claim for me earlier.
But,
so,
like, in other words, I'm pretty sure all it is like a list of, like, you just go one by one, right? But
yeah.
So, I mean...
So you have to, like, the affidavit of records you can attach a schedule to, like, so it has 3 categories, if I'm recalling correctly. You're putting me on the spot here, so let's see how well I do. It has 3 categories of records. Ones that are relevant, all of them are presumably relevant material to the action. Anything that's not relevant material to your action, you don't have to disclose, right? So that's like the first test. So anything relevant material to your action must be disclosed unless it's privileged, right? So the first set of documents, the first schedule or whatever, is documents that are relevant material to your action that are not privileged in any way or that there's no reason for withholding them. Mm-hmm. The second category relates to documents that you're withholding. You don't have to specifically list those documents. You can just say general categories of why you're withholding them, whether they're, if you've ever had a lawyer, if they're solicitor-client privilege, if they're litigation privilege, I don't know. There's lots of different types of privilege. Probably you won't have any of those, I'm guessing.
Myself, I will not, no.
Yeah. So you'd be looking at disclosing anything. So what we normally do is we just make a table of all the documents. You're just going to make an index. It's like a table of contents. And you are going to, you're just going to like separate them out one document at a time. You're going to put tabs in between them, and you're just going to call them different things. So say you have an email string, where it's like a string of emails all relating to the same thing. You can disclose that as one document of 5 pages. So you're going to say, you're just going to kind of like call it like email string between these parties, and you're going to put the dates in a different column, and you're going to put the number of pages. So the rules of court dictate, which maybe I should print off for you. Do you have that?
Well, you mean the whole thing? Because it's a huge document.
No. Yeah, I'm not going to. I won't print the whole thing, but they do have form and contents about this. Rule 5.6 tells you exactly what you need to do. Right.
I can just look that up.
Okay. So it's Rule 5.6 in the Rules of Court, and this just make sure you're doing everything that you have to do on here. It'll give you. Okay. Yeah, just make sure you're doing everything. But from my just recollection, without looking at an actual document. You're just gonna say on the form, the affidavit of records form that I can't pull up. You're just gonna say, please see attached schedule. Right. Right, and then you're gonna make an index, and then following the index, you'll be attaching all of those as essentially like exhibits. Okay. Yeah. So you're gonna have an email string. There might be pictures or whatever. You know, anything kind of like relating to the same thing you can lump together.
Right.
They don't all have to be like, if you have a set of 20 pictures taken on the same day or relating to the same event, you can attach those as the same exhibit. Right? I'm trying to think what else there might be, like any but you probably wouldn't have any contracts or anything.
Right.
But, yeah, does that make sense?
Well, I mean, the thing about my particular case is that most, if not all of the information is on this LIRB record, but a lot of it was provided by me. So the stuff that I provided, obviously, I have complete permission to use, even though it's on this LIRB record. Yeah. I still have permission to use it because I provided it. Right. So the thing is that police files are on this LIRB record, and so obviously those are things I want to use because I have like redacted copies of those that were given to me by the FOIP unit, but on the LIRB records are the unredacted ones, so obviously I'm going to want to use those. Okay. But the thing about those is that I have to believe that the police are going to provide those. Yeah. Right? Those are of their control. They should, yeah. So I don't have to list those because they're presumably, and you have to believe that they're going to provide those.
Yeah, and if you don't have copies of them, then you can't provide them, right? I'd probably provide the redacted ones, just in case, because they are obviously relevant material. They might not be the full amount. You can also later do the unredacted ones if you get them. Mm-hmm. It's always better to over-disclose rather than under-disclose, right? So if you have copies of the redacted ones now, I put them in, because you have them and they're relevant material. You don't want to be accused of withholding anything. And then later, once the unredacted copies come in, you can either put those in a supplementary affidavit, or you're right, they would have to, the police records, they would presumably have to.
Well, that's the thing. You'd think that that'd be their part
should.
of the story.
Yeah, absolutely.
Right.
Absolutely.
And so on that note, if they don't, because I know what exists, for example, officers' notes, right? Handwritten notes. Yeah. If I just have the redacted ones, and the unredacted ones are on the LIRB record. So if they don't disclose them on their end, I can ask for those, right? I can make a request for things that I know that should exist, absolutely, and they will have to provide.
Yeah, them. For sure. Now, whether or not they disclose them to you, this is not something I know the answer to, but there might be some argument for privilege. I don't know. I don't see why, but there could potentially be some argument for privilege there. Right. I don't know how police records work. But yeah, you're absolutely entitled to ask for them if you know they exist.
So I guess the question of how to list the LIRB record is by the relevant documents. Like you can't just say the LIRB record as a title of what you're saying.
I don't really know what the LIRB, I've never seen a LIRB record before. Is it like a report?
Well, it's like in my particular case, it's an 1,100-page PDF. Okay. So, in other words...
And is it just a bunch of documents, or is it framed in the way of a report, or...
Well, it's just it's, in my opinion, it's kind of ridiculous that it's all in one PDF, and they gave me a disc that has this 1,100-page PDF, and then it has bookmarks at the beginning, so you can, I think, click on the bookmarks to jump to sections. Okay. But it's all in one PDF, so, I mean...
So you're wondering whether to split that up?
You probably would, right?
If it has a bookmark, if it has a table of contents, I just leave it as one.
Oh?
Yeah, because the thing is, the only benefit to splitting it up would be it's for the ease of court to find documents when you're in trial and you're saying, I'd like to refer the court to this document, right? Mm-hmm. So if it's already identified in an original table of contents, why would you make it more difficult by splitting it up, right? Just do it as one exhibit, and then you can each page, of course, would have to be numbered, which I'm assuming it already is in this 1,100-page thing. Yeah. Then you can just refer to document 556 of tab so and so of your affidavit, which would be the LIRB record. Right. That's what I would do. I wouldn't split it up any more than it already is. If it's in a nice, coherent-ish format, just leave it that way and just disclose it all as one.
Well, I guess the thing, in my opinion, there's a lot of it that's fluff or padding. In other words, there's emails there that I don't think are relevant, and that's why I was kind of thinking, for simplicity, you could refer to it as the LIRB record and include the whole thing, but for practicality, I think it kind of makes sense to, just include the parts.
Yeah, without seeing it, I probably can't really give you very good advice. Honestly, if it's if there's a question of whether it's not relevant,
Parts
but
of
it
it,
can't
yeah.
really like hurt you, I would just err on the side of disclosing it.
And just include it all?
Yeah, because it looks a little bit weird if you're disclosing part of a record, or
Right.
a already produced document, but not all
Oh,
of it.
I see.
As a court,
Well,
I would
I
want
make-
to see it
I-
all to know, like, hey, listen, this is my case. Otherwise, there might be a bit of an adverse inference for you having taken pages out of it on the basis that you thought that it was not relevant, right?
Right.
So
Okay.
if it's all in one document relating to this specific, just disclosure, or the the LURB record, I would just leave it in.
And just call it
Just
the
disclose the whole
LURB
thing and
record.
call it the LURB record.
and
There
say-
are parts of that document that are relevant that I would assume the whole thing would be relevant, because
Right.
I would rather not see it.
Well, that's an
broken
interesting
apart.
point. And I totally understand where you're coming from in terms of seeing a complete package as opposed to
Yeah.
excerpted.
Yeah, it's
pieces.
always better to look good in front of the court, like you're erring on the side of disclosure rather than not.
But on that note, you wouldn't be printing this thing off, right? You'd be actually able to refer to it on like a laptop or something.
Generally,
Like you wouldn't print off 1,100 pages.
so if you're producing it in court, you'll probably eventually have to
Is
produce
that
it.
true? As a
Yeah.
physical document?
As
Because
a
that's
physical
ridiculous,
document,
really,
yeah,
isn't
you should
it?
see, for exchange between parties, you can do it. You can do it via
Digitally?
digital copy.
Mhm.
To the court, though, I don't know. It's a good question. I don't know if we typically do it in digital copy or paper. I've always only done paper. I don't even know if that's an option, because some of the, no offense to any of the judges or anything, but they're a little old school, so they don't really, a lot of them want physical copies. So that might be something you have to talk to the clerks about. I don't know if you can produce it in electronic copy. For sure, for exchanging between defendants, between parties, you can. That's no worries. But
Right.
eventually you might need a written copy.
Huh, interesting.
Okay.
Okay.
So we're over time here. So I want to answer the rest of your questions as quick as I can.
Okay, so I guess, one other thing, okay, so I guess my first step is to contact the parties and ask whether there's any problem with extending the affidavit of records
Yeah.
to, like, I don't even know what date it's going to be, because the hearing is August the 24th, but there's probably going to be submissions that have to go back and discussion that has to be done. Like, I don't think a decision is going to be made on that day. So, in other words, LURB would know what the general time frame of the decision